મારે લેખિતમાં વાંધા આવે. હા, રિપોર્ટ આપ્યો છે. જી સર. પંદર સાહેબ મંગળવાર રાખો. ઉચિત ચાર્જ સાહેબ આવતી તારીખે દઈ દો સાહેબ, એ તૈયાર નથી થયો સાહેબ. હાજી 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 સાહેબ.
RC 19. હા, સિરિયલ નંબર 19. હા ના ની 72-19. એમાં સાહેબ રિપોર્ટ આપું છું, સાહેબને અચાનક જવાનું થયું છે વેરાવળ. હા 20 છે, સિરિયલ નંબર 20. જી સાહેબ. અગિયાર સાથે નહીં.
ફરિયાદીને હાજર રહેવાની સૂચના આપી છે, 5-7 મિનિટમાં પહોંચતા હશે. અને 182 માં અમે પેલામાં હાઈકોર્ટમાં ગયા છે, એનો રિપોર્ટ ને સ્ટેટસ રજૂ કરી દીધું છે. સર, પેલી અપીલમાં મારી ગેરહાજરીમાં પેલા આવે એમના વકીલ સાહેબ, મને સાંભળો તો મને વાંધો નથી, હું બીજું પતાવીને પાછો આવું છું.
सीरियल नंबर 5 एग्जाम सीरियल नंबर 5 सीरियल नंबर 5 पर एग्जाम सर જી સાહેબ સાહેબ હું રસ્તામાં સાચી વાત છે થોડુંક મમ્મીને અહીંયા દવાખાનાનું કામ હતું ને એટલે સાહેબ લેટ થઈ ગયું બાકી સોરી સાહેબ હવે નહીં સોરી સાહેબ મારી ભૂલ છે જી સાહેબ હા
બપોરે આવો. મળશે વળી. એટલે બીજે બધાની કોઈની જરૂર નહીં પડે. મારે એ જાણવું હતું કે પેલા એક આર્ગ્યુમેન્ટ્સ આપેલા હતા, રિટન આર્ગ્યુમેન્ટ્સ. હા, હવે હું એક્સપ્લેન કરીશ. આઈ વિલ એક્સપ્લેન સર ફ્રોમ ધ yes sir. If we see the appeal memo begins from page number 1. Now there your honor will find that what is the extent of claim involved. આ છે ને પેપર બુક આવી જ છે ને. હા. So on page number 1 your honor will find that government has filed a suit against me for recovering a sum of rupees 1,11,362, and that was a special suit also decided by the Civil Judge Senior Division Junagadh, who dismissed the plaintiff suit with cause and ordered that the counterclaim of the defendant to the tune of rupees 1,21,000. Then your honor will find the grounds. Now grounds માં હું એક જ વસ્તુ કહું છું કે kindly see, ground C may be seen. The appellant judge erred in holding that the appellant has committed breach of contract by not handing over the site and not providing design drawings and maps and not making all required land and materials to the respondent. Second, then is about this. Then E may be seen. The learned judge has erred in not holding that the appellant legally terminated the contract under clause 3C of the condition of the contract. This is important. Clause 3, I will point out how clause 3 comes in the picture. Then the learned judge has erred in not holding that the appellant is entitled to claim rupees so and so. This is the risk and cost amount 52,000, and all these amounts are there. Then only K may be seen. There's some error is there which I am pointing out. The trial court has not awarded 75,000. Trial court has awarded 50%, 37.500. So the challenge to this, I think my learned friend will correct it. It is only 37,500. From the judgment I can point out. Now kindly see the judgment. A judgment is very lucid and very elaborate. I am not going to read each and everything, but some of the important facts which need to be pointed out, they are highlighted. If your honor permits me, I can just pass over my written notes. One may be given, I will give to my learned friend also. This is happy. He does the so. आप इलाम दो પછી સાહેબ ને આપ first yes sir. Now sir, all these things take copy sir. We are not at variance about the tender agreement. Kindly see, tender invited was on 8/8/67. This I have taken from the pleadings of the parties. Then estimated cost is 629, accepted tender cost is 699. Then security deposit was given 12,600. Then your honor will find the date of work order, that is 14/11/67. We don't dispute about that. Then stipulated period was 24 months. I have to complete it, sir, within the period of 24 months. Then date of completion according to 24 months is 13/11/69. Now contract agreement. We are bound by the terms of the contract agreement. That is exhibit 38, exhibit 148 is the original and exhibit 30 is the Xerox copy. We are not at variance about that. Your honor will find in the judgment I will point out. Now then legal notice by contractor is 26/12/70. Now kindly take the note of the date. The original time limit was over on 13/11/69. On the above two lines, I have given the date of completion was 13/11/69. But then I had to give notice after 1 year, 26/12/70. I continued, both the parties continued under the contract because it is our case, the time was not the essence of the contract. But this is civil and engineering contracts, time is never essence of the contract. That is one of the main contention which the Honorable Court has held in my favor, relying upon the judgment of Honorable Supreme Court, 79 Supreme Court, I may just pass over the copy, and 720 page, where it is held that in civil engineering contracts, what is to be seen is the intention of the parties. For gathering the intention of the parties, we have to see the clauses of the tender. Now, in Exhibit 48, Your Honor will find that there is clause 2 and clause 3. I have on my hand clause 2 and clause 3, but that clause 2 and 3 is also referred in the judgment. Therefore, I am not giving it separately. Now, sir, what happened? I applied for the time around this 13/11/69. Look here, the work is not completed, admitted. There was slow work because diversion was not there. Land acquisition problem was there. Some item of extra item had cropped up and some metal there because there is item number 9. It is a hand crushed metal which I have to bring on site. I brought hand crushed. It is in the specification. The department said, we don't want hand crushed. We want machine crushed. I had to take it back. That consumed the time. If I was at the fault, department could have terminated my contract before 13/11/69. Department does not terminate. Because if I am a bad man, I should have been told, yes, we don't want because we want to do the work at your risk and cost. Department has not done so. Department was knowing that there is some difficulty. Therefore, I was allowed to carry out the work. Now, thereafter, I served notice on 26/12/70. Now, because I couldn't get any positive response either at site or at Gandhinagar, I have written letters, but my issue of extension of time was not decided. I applied twice. I'll show Your Honor, there is a finding of the court that I applied twice for the extension of time. But the department does not grant extension, does not even decide. And ultimately, department on 10/2/71, Your Honor will find at serial number 11, it is admitted fact. They terminated the contract under clause 3C. Now we have to see, there is a clause 2, clause 3. Clause 2 says that you have to levy penalty up to the level of security deposit. And then forfeit the amount. Then you can go to clause 3. As the serial number goes, first I'll point out from the judgment also, department has not applied clause 2. Direct they applied clause 3. There is no order. My submission is this. There is no order under clause 2 forfeiting the security. I'm not repeating, sir. I will be, because judgment will read. Then your honor will find, then state filed a suit on 20th/7/74. Now claim amount is 1 lakh so and so. Then my WS and CC is exhibit 19. Then counter claim is my 2 lakh 9. I'm not awarded entire amount, sir. I am awarded part amount after due consideration of my claims. Then judgment is dated 31. Then suit of the estate dismissed and counter claim is allowed. Issue framed by the court is exhibit 29. Now kindly turn to exhibit 29 of the judgment. Page number 12. So from page number 1 to page number 12, Your Honor, I have given this sequence of the events. So આપણે એ બધું વાંચવાની જરૂર નહીં પડે, પણ પેલું જે મેં સિક્વન્સ બનાવી આપ્યા છે એમાં જ છે. હવે આપણે now we have to see what are the issues before the court. Now whether the plaintiff discloses cause of action. Sir, because there is clause 30. Now court, there was an issue. My pleading is there. In my written statement, Your Honor will find written statement exhibit 19. Your Honor will find that I have raised a contention that there is a clause 30 under the agreement which provides that there should be paragraph 2 of my written statement, that there should be a decision of the superintending engineer before filing a suit. The department has said that they have not taken such a decision. So this contention is otherwise also not materially affecting my case. The court has fortunately said that there is no cause of action which requires to be sustained. Now issue number, so whether the plaintiff discloses cause of action, the court has said in my favor that it doesn't disclose. But we are not harping on it. It has become irrelevant. Now second, whether the suit is time barred. I have said it is in time. And the court has also said, no, suit is not time barred. So it is in favor of the government, sir. Now issue number 3, whether this court has jurisdiction to hear this suit. Yes, I am not agitating, and court has rightly said it, this court has. Then 4, whether the defendants committed breach of contract by not starting the contract work in time and not doing it according to schedule. Now this is issue number 4, which is material. For the time being, Your Honor, only keep this in mind that 4 is material. Then 5, whether the plaintiff committed breach of contract, this is also material. And then 6, whether the plaintiff wrongly imposed penalty. This is, I mean, ancillary issue. And then 7, whether the metal hand broken metal was wrongly rejected. The main issue is issue number 8. Issue number 8 with issue number 4 and 5. Now issue number 8, if we read, sir, whether the plaintiff legally terminated the contract under clause 3C of the conditions of the contract. Now, the discussion thereof will show that issue number 3 and issue number 8 is fortunately taken as issue number 1. Oh, para 7. Running page number 14, sir. Now, why this issue is important, I just take 1 minute. If I can point out that very termination of the contract is wrong, then all subsequent act of risk and cost, everything will go on. That is why court has considered issue number 8 important. In this suit, in all, 21 issues have been framed by the detained civil justice citizen. And all these issues, the most important issue in this case is issue number 8 regarding legality of valid termination of the contract, wherein the plaintiff is required to prove that the contract of the defendant was legally terminated, and if it is turned out that the contract of the defendant is not legally terminated, in that case, the entire suit of the plaintiff fails, and the plaintiff will not be entitled for any damage or suit claim, and on the contrary, the defendant will be entitled to recover the amount of his secure deposit. In this suit, the plaintiff has examined, now it is the oral evidence. In this suit, plaintiff has examined 3 witnesses, PW1, PW2. Exhibit numbers are there, which I have also mentioned in my sheet, oral evidence separately. So your honor may just only take note of it. In this suit, so-and-so 148. Copy of the said agreement is also produced at Exhibit 38, and as such, Exhibit 148 and 38, both these documents are the original agreements, and the true copy of it is respectively. So this is the Gita between me and my learned friend, government. We have to decide according to this. This agreement is required in one unusual B2 form. Suit contract is the B2 form is used from last 100 years, more than I don't remember, but it is said that it is used. There are 2 forms, sir, B1, B2. B2 is the item rate. Each item and rate is given, whereas B1 is a percentage rate. Whole tender plus minus percentage. So we are concerned only for a limited purpose. Say the defendant, as per the agreement, to construct the bridge over, this is the name of the work, bridge over the river Ojar near village Visavadar Road and near Khamlia village. It is an admitted fact that the tenders were invited on so and so, so and so, so and so. These things we are not disputing. I may pass over because I have also given the details which my learned friend is also having. Now kindly see page 16. First line. Looking to the agreement, it is found that it consists of 2 schedules. Schedule A shows the materials to be supplied at constant rate, and Schedule B shows that the items to be done. Only 1 minute, sir. In the last of the agreement, your honor will find there is a separate schedule which A and B, they are, it is in every tender, B2 tender. And there, how many items I have to do and how many this material is to be supplied. This is there. Now next, sir. It is submitted before me by so and so learned advocate for the defendant that as per clause 13 of the agreement 148, it was the duty of the plaintiff to supply all the working drawings, certified copy of the design, etc., along with the work order. And it is also submitted that the contract creates mutual bilateral reciprocal contractual obligation. It is the rest submitted. So clause 13 is to be seen by your honor, which तो मूलचंद में एग्रीमेंट लाया सर हाँ लाओ Sir, I have got another agreement of other party, but B2 form, all clauses are same, and I have brought it because I wanted not to disturb the old record. So clause 13 only says this thing, that the contractor should be supplied all drawings at the time of issuing the work order, which my cases they didn't supply because they were not ready. It is forcefully submitted before me by so and so that the a defendant is entitled to receive the entire site of the work along with the work order or soon thereafter, because it is a time-bound period, sir. If I am told to go, I must have everything, site and drawings. And that if the said work site is not handed over by the plaintiff along with the work order, then at least it must be received by the defendant contractor when demanded by him. It is also submitted by so that it was the duty cast upon the plaintiff to give diversion to enable the traffic to pass from the diversion, and only after such diversion the work can be done by the defendant. This is my second point. First is drawings, second is diversion. No, because it is a running road. If I have to do the work on running road, then definitely, and it is not my item. Sir, B2 item will not show that there was a diversion, that for which I have to provide it. It is the department, and department has not said no. The diversion was not within the scope of them. They have not said that diversion was to be done by the contractor, in other words. So we are not disputing that diversion was not item in Schedule B. And department also has said in the written statement, in the pleading, that diversion was to be done by the contractor at his own expenses. So it is very clear. Now next, sir. On the point of diversion, it is urged before me that the plaintiff did not provide and maintain to diversion, and therefore throughout the traffic was passing entire, the bridge was to be constructed on the existing road. That the plaintiff was fully aware of the difficulties of the defendant because the plaintiff had brought to the notice of the defendant from time to time. Another difficulty was regarding supply of the required steel in the time. Now, this is also not disputed because Schedule A says that steel was to be supplied by the department. And that too in the required quantity. It is also argued by the learned advocate Shri Sonso that over and above these difficulties and harassment of the department imposed the penalty as per the later dated 28/12/69. Now kindly see 28/12/69. My time limit is over on 13/11/69. Now, if you don't impose the penalty within my original period of contract, that means I was a good person. Otherwise, you would impose the penalty immediately. But department is not imposing. After the time limit, they start the process of this. And that too, sir, without extending the contract period. They have not extended my contract period. And all these findings, Your Honor, will find in the Exhibit 48 by the executor and wrongly deducted rupees 33,000 towards penalty through RA bills and threatened to deduct more penalty of rupees 62,000. Ultimately terminated the contract on 10/2/71. Sir, that is Exhibit 56 for Your Honor's immediate noting of that. I have also mentioned in this. As per Exhibit 50, and the said order is challenged by this issue. At this stage, I refer the deposition. Now oral evidence is most. I refer the deposition of PW1, Dhiretlar Harichand Vora, 120. He has admitted in the cross-examination that the defendant did write the letters to the department regarding the position of site land, diversion, design and drawings. And he has also admitted that the defendant also complained by letters that the department was not supplying the iron bar to the defendants in required quantity. The PWD2 Walji Haribai has also admitted in the cross-examination that no any working drawing was supplied. Sir, clause 13. No any working drawing was supplied to the department along with the work order, and there was a change in the design of the construction work, and after giving the maps of the said work, once the drawings are given, then changes are made. Sir, I don't say they cannot make. They can make. There may be engineering construction, there may be variance of strata requirement, but then time you have to extend. then you have to, if there is an extra item, you have to pay for it. My case is they didn't extend the time limit. This PW2 has also specifically admitted that there were so many letters from the defendant complaining that the department was not supplying the steel for the construction work, and which was a duty and obligation on the shoulder of the plaintiff as per the terms and conditions of the agreement. He has also admitted that no any item-wise program was fixed. Now, this is most important, and there is a decision of this honorable court. Sir, what has happened? I may point out. Tender happen. In the tender clause 2, in clause 2, this is my copy, but your honor will find the same verbatim same. In clause 2, what is important? There is a general schedule which they say 1/4 of work and 1/2 of the time. One half of the time, 1/2 of the 1/2 of the work, अर्धो काम अर्धी मुद्दत में 3/4 work, 3/4 भाग. Reasonable progress is also. Now after this, your honor will find note. This note is very important. કારણ કે engineering, civil engineering works માં શું થાય? Some situation may be different than what was contemplated by the parties. So note is important. In clause 2, the note says the quantity of the work means schedule B quantity of the work to be done within a particular time to be specified above means 1/4 be fixed by the officer competent to accept the contract after taking into consideration the circumstances of each case. There may be different situation he has to consider. Each case and entered in the blank space kept for the purpose, and the contractor shall abide by the program of detailed progress laid down by the executive engineer. Now, in this case, there was a main issue that is there any program prepared by the executive engineer for all the items in the tender? કારણ કે આ તો સ્ટીરિયોટાઇપ કહેવાય. સિચ્યુએશન જે છે એ જોઈને શું ફેરફાર કર્યો? Admittedly, there is no problem. And Gujarat High Court, Honorable Gujarat High Court has held that if there is no such program, then definitely there is no application of clause 2. કારણ કે clause, there was no consensus ad idem કે આટલી progress, આ આઇટમોની progress મારે આટલા સમયમાં પૂર્ણ કરવી છે. There was no such schedule, no such program. Therefore, in my humble submission, there is a breach of clause 2 prima facie on this ground. Now, Your Honor, I may proceed further. This is what is according to the person. Yes. 58. There are 2 exhibits. Now, I will sit, sir. I can find out it easily because I have my hands. Huh?
Agreement is 148.
Ah,
Exhibit 148.
148. So my friend has seen. આ છે એમાં નોટ જ છે. અને આ જજમેન્ટમાં પણ છે. I proceed further. Itemized program was the obligated duty on the part of the defendant as per the clause B of the agreement. It is in the evidence of PW2 that it was open foundation work and the work was done accordingly in open foundation, and further that all the first work was completed by the defendant and only some decking work was to be done, and according to the said witness, the work of foundation is a difficult one, and so far as the decking work is concerned, only 2 or 3 plans were left out to be done. Now, sir, we have seen that 6 lakhs નું 6 લાખનું કામ છે એટલે 4.5 લાખનું કામ મેં પૂરું કર્યું છે. It is not that I have abandoned the work, but because time limit is not granted, therefore I said that, sir, I cannot work. The PW number 3, Shantilal Shamji Parekh, in his deposition 145 has stated that if he did know whether the item-wise program was given to the defendant or not, and according to him, it was not necessary to give such program to the contractor. But it is obligatory. The clause itself says that item-wise program has to be given, and the judgments are there. Sir, that judgment was circulated all over the PWD department in the state of Gujarat. But as we know, that it is very difficult to push up the bureaucrats in there. Now we go further, sir. PW3 so and so necessary to give such program. It is the suggestion from the defendant's advocate to number 3 that when the work order was given to the defendant, till then no land was acquired by the government, and it is also a suggestion and allegation that even the diversion was not completed by the plaintiff, which was obligatory duty of the plaintiff. The DW one means myself, sir, the contractor who was serving in the firm, defendant number 1, so and so, so and so, in his deposition, that is exhibit 160, sir, is fully aware about this disputed construction work, and he was stated that as per Schedule A, the department was required to supply 106 metric tons steel, and the defendant, and that alone the work order, no any maps or drawings were supplied to the defendant, and no any item-wise program was fixed by the plaintiff as per Schedule B of Exhibit 38, and that in all there were 42 items in Schedule B. He has also stated the difficulties for which the work was not completed as per the schedule. And according to him, the difficulties were regarding diversion supply. So he has supported my case. I'm not reading each and every word. Sir, then the middle of it. In short, according to DV number 1, Madhavlal so and so, there were hurdles and difficulties which delayed the work, and the defendant was not able to complete the work as per the schedule. It is vehemently argued in light of this deposition, and as per the terms and conditions of the agreement so and so, clause 2, the penalty is to be imposed for delayed performance, and there is also clause 6, according to which extension in time can be granted if there are sufficient reasons. Now 2 and 6 go together as per judgment 79 Supreme Court, that if these two clauses are there, then intention of the parties was that the time is not the essence of the law. It can be extended, put you some penalty or compensation, but we will extend the time. In this case, department admittedly, though I applied, not taken any decision upon it. And that is why court has held that termination under 3 would be treated as wrong. It is forcefully argued by the learned that it is settled law that whenever in an agreement, if there is a provision of penalty and or provision for the extension of time, the time is never the essence of the contract. In this connection, the defendants relied upon the latest judgment of, this is what the judgment I refer, page number 70, and also relied upon, I can, sir, give the fresh copy of this judgment for your honors. Be a copy of it. This is the same judgment, but SCC on. Okay. Same, we are 79. Then reported judgment of Honorable Gujarat High Court delivered in first appeal number 99369, decided by the Honorable Justice D.P. Desai and Justice Shri N.H. Bhatt on 23/7/75. It is mainly contended by the learned advocates also that the time was not the essence of the contest. Subsequently, sir, here I may stop. It cannot be said that time cannot be made essence subsequently. I can definitely fix up a reasonable time, considering the situation that now all issues are solved. Now I fix the time and inform that your time will be now considered extended up to this date. Beyond that, if you don't complete the work, the contract will be terminated under clause 3. That is what Supreme Court has said, that you can always fix the time subsequently also. But in this case, department did not extend the decided the issue of time. And he has drawn my attention towards the deposition of number 2, Waljibai Haribai Kabaria at exhibit 138, and the defendant witness number Madhav Udhavji Mistri 160. PW2 in his cross-examination has admitted no any stipulated time was given to the defendant contractor to complete a particular item. That is to say, the item-wise program was not given to the defendant contractor, though it was the duty of the plaintiff to give such item-wise program. He has also admitted that there were letters from the defendant that the department was not supplying the materials, namely steel, etc., for the said construction work. It is the submission from the defendant side that time was not the essence of the contract, and the same is not made the essence of the contract even subsequent. Clause 2 must have લખેલું છે કે time is the essence of the contract. This is their proposition, that do or die, complete the work within these 2 days, that is on 16, 12, and 69, 24. They say time is essence, but there is the clause of waiving penalty and the clause of extension of time. So that is why Supreme Court has said that you see the intention of the parties. Now thereafter, sir, and the termination of the contract is illegal and the plaintiff could not forfeit the amount of ASD and not entitled for damage. In support of this argument, same judgment I have said, and there is another judgment, sir, unreported judgment, 68-66, decided by Honorable Justice GP Mehta and Shri S.N. Patel on so-and-so, AR 79 Supreme Court. These are the 3 judgments which are across the Alandi River. Now, in that case, this was the aqueduct work. The court has gone into the detail of that judgment, that there was a work of aqueduct and how there the Honorable High Court decided the time cannot be essence of the law. And similar clauses, sir, clause 2 and 3 same, 6 same, all other clauses same. So I pass over this. Kindly turn to page number 20. There in the middle, I would like to read after 4th, 5th line, rejection of materials on improper grounds by government officers, etc., over which the plaintiff had no control, the work was delayed, and that the extension of time, which was permissible under the contract, had been wrongly refused by the officers of the respondent department. In the said judgment, the defendant's advocate relied upon clause 2 of the conditions of contract, where not only time was stated to be the essence of the contract, but even for the completion of proportionate work, the specific period has been specified, and it was argued by the defendant's advocate. In that case, then failure to complete the work within means terminated, and in that case, their lordship has held as under. Sir, this is the ratio of the judgment which the trial court has duly considered, and therefore finding, kindly see. In the above referred case, the lordship has referred clause 2 and clause 6 of the contract, which are similar to clause 2 and 6. In the present case, the clause 2 and clause 6 are as under. So I'm not reading clause 2, sir, completely. If we see, Your Honor will find what I said, the due diligence time being in bracket માં એ જ પેજ ઉપર સાહેબ 21 નંબર પેજમાં ક્લોઝ 2 ના છેલ્લી લાઈનમાં લખેલું time being deemed to be the essence of the contract. અને પછી next page, sir, clause 6, the same clauses are there. And then looking to the facts and the circumstances of the AR 79, it is very identical case which is applicable in the present case also. And in view of the above, there is no application of clause 2 of the agreement, exhibit 13, and there could not be any application of clause 3 of the agreement if there is no application of clause 2, because the condition precedent for applying clause 3 of the contract is that there should be penalty to the extent of secret deposit under clause 2 of the agreement. And if there is no such penalty to the extent of the secret deposit, there cannot be any action under clause 3 of the agreement. It is decided in the unreported judgment of the Gujarat Honorable Court, first appeal number 68, dated so and so. The clause 3 is read. Sir, then court has dealt with the same clause. Now kindly see in the very first line, in any case in which under any clauses of this contract, the contractor shall have rendered himself liable to any compensation amounting to the whole of secure deposit, whether paid in one sum or deducted by or in the case of abandonment of the or on the account of death of the contractor or any other cause. The power is given to the executing unit. Now, there should be order of penalty under clause 2 communicated to the contractor with a show cause notice, because this is a penal action. Principles of natural justice demand that I must be asked to give a show cause by show cause so that I can explain that this is the situation. Sir, admittedly, no show cause notice. Then your honor may kindly pass over clause 3. In the event of any of the above clauses being adopted by the agreement, the contractor shall have no claim. That is about the no claim by the contractor. But that issue is also decided by the Honorable High Court in the recent judgment, which I have also brought it. It is the division bench judgment of a very recent time. I brought a copy. Honorable Justice Acting Chief Justice Bhaskar Bhattacharya and Justice Devi Padiwal. That copy I will give, sir. That will touch only this aspect, that it is the executive engineer who has to take the decision. In the case the plaintiff was entered into the contract on second, this is an example which is given in that case. Now your honor can pass over to the findings, page 26, and it is last but 10th para, considering 10th or 11th. I think pages are telling 26. Not telling? Sir? Sir, then paragraph I will point out. Pages are not telling, no? Sir, para 7, if your honor can. I am, sir, page number 26. Paper book, page number 26. And the Shelly line che, diversion and also all these. Yes, yes. While in the present case. એનાથી 5 લાઈન ઉપર જોશો તો સાહેબ considering the above ratio. I am reading that. Considering the above ratio of the judgment, it is crystal clear that as per contractual obligations, the defendant must get, along with the work order, the entire side, and he must be given, as per clause 13, all the design drawings, diagrams, and etc., so that the contractor can start the work and achieve the progress in the terms of the contract. While in the present case, the plaintiff has failed to perform their contractual obligations as they did not hand over the site in the entirety in the beginning and also did not provide for all the design maps, etc., and did not make available all the required land and material and did not maintain diversion to enable the traffic to pass from the diversion, and all these difficulties and failures on the part of the plaintiff have been stated in the letters written by the defendant, namely so and so, so and so, so and so. The work order was given on so and so, and there was a contract to complete the work within 24 months. And as such, the work was required to be completed on so and so. Then it is also on record that the plaintiff gave a telegraphic notice on 19/12/68 intimating the defendant to work according. Then, sir, this all is detailed, but the findings Your Honor will find on next page. Last line. It is admitted that the hand, broken metal and other, these are the factual issues. My submission is this, sir. So far as factual issues are concerned, of course, this is suit is in, appeal is in continuation. But if two views are possible, then the view taken by the trial court is got to be affirmed, unless the view is found to be perverse. Now, there is nothing, no perversity is alleged, nothing is brought on the record to show that it is admitted that a hand broken. So I negate the submission made by the learned Assistant Government Engineer Shri Waja before me and apply the ratio of the judgment in first submission also. I hold that the clause 3 of the agreement also is not attracted in the present case, as there should be penalty to the extent of the security deposit under clause 2 of the agreement, and if there is no such penalty to the extent of the security deposit, the plaintiff cannot take any action under clause 3 of the agreement. Now, termination is under clause 3. I think they will not dispute on the point that they have terminated my clause. It is also pertinent to note that no any show cause notice was given for imposing the penalty and for terminating the contract under the clause 3 of the agreement, and further that no contract was in existence as the original time limit had already expired and no extension of time was granted. Sir, if they show that time was extended in writing, communicated to me, this point will go on. Further, that the executive engineer debarred himself from so and so, so and so, and no any opportunity has been given to hear the defendant in person, considering the facts and record on the and the documents referred here and above. I hold that the time was not the essence of the contract in the present case in the light of applying the ratio of the above authorities, and as such it is crystal clear that the plaintiff has wrongly terminated the contract under clause 3 of the contract. Hence, I decide issue number 8 in the negative. This is complete filing. I would say no error committed. The trial court has considered documentary evidence, oral evidence, interpreted the terms of the clauses and the judgment. Now, can we see clause 30? The issue number 1 I will not read it because it has nothing to do with the present matter. Now, once that terminated, પણ એમાં એક જ વસ્તુ લખી છે ક્લોઝ 30 માં આર્બિટ્રેશન ક્લોઝ છે અને જજમેન્ટ છે કોયાજીનું બોમ્બે હાઈકોર્ટ. I think it is too old the judgment to be now referred. Therefore, issue number 1 finding is there. Except issue number 2 પહેલાની finding આવશે, આપ જોશો ને. I have mentioned in the beginning of the discussion of this issue that the clause 30 of Exhibit 38 of clause 30 in the civil suit number so and so, both are identical. The decision of the Bombay High Court is helpful to the defendant. It is on record that in the present case, no any decision from the arbitration, namely from the superintending engineer, has been obtained by the executive engineer. Therefore, in view of the above judgment, the plaintiff's case does not disclose any cause of action, since it is a condition precedent for taking the decision from the competent authority, complying the ratio of the above judgment. I therefore decide issue number 1 accordingly in favor. It is decided in my favor. If my learned friend shows any judgment contrary to Koyaji's judgment of Bombay High Court, then only. But it has, in my humble submission, no relevancy at all now. Issue number 3, sir, is about the jurisdiction, which I do not agitate. I say that yes, this honorable court has jurisdiction. Then issue number 4, as I already pointed out, that was about the breach of the contract. Now, the present contract creates mutual, bilateral, reciprocal contractual obligation. I skipped 3-4 lines. I have fully discussed while discussing issue number 8 that the plaintiff PW department did not supply the working drawings and designs in time, and that the seed quantity was also not supplied to the defendant as per its requirement. No any diversion was constructed by the plaintiff for the traffic, and that there was delay in the acquisition of land for the surrounding area. All these difficulties of the defendant have already been proved, and they are incorporated in issue number 8, and therefore I do not repeat the same discussion here. It is urged before me by Suhan that as per clause 13 of the, then again it is a repetition about 13 and all. Then next page. Sir, this is in the middle of the next page is a crucial point which touches the issue of extension of time. I refer it 51. આ તારીખો આપી છે ને 14/11/66 એના પછી. At this stage, I refer Exhibit 51, a letter dated 3/12/69, written by the defendant to the executive engineer Junagadh, in which he has prayed to extend the time of the contract, and he has mentioned the reasons for the extension of time, in which he has stated that the traffic was not going on from the alignment of the bridge, and that there was unseasonal rain and there was flood in the river Ojat, and besides there was no diversion constructed by the plaintiff up to the February 68, and therefore there was delay in the work. He has also mentioned in the said letter, Exhibit 51, that the executive engineer in his personal visit rejected the metal which was hand broken and insisted on machine crushed metal, which was against the terms and conditions of the contract. It is also mentioned that the order of the contract was also received late from the department, and one of the reasons was that there was a shortage of Khanki metal in the district of Junagadh, for which he had to move to other districts to bring the Khanki metal. This exhibit 51 shows that there was no exclusive delay on the part of the defendant, and therefore the provision of section 51 to 54 of the Contract Act, the time essence is relating to that, is attracted in this case because it was the first and foremost duty of the plaintiff to perform his obligation, but as a matter of fact, the plaintiff has failed to perform his duty. Not only that, but the plaintiff terminated the contract of the defendant illegally, which is held by this court while deciding issue number 8. And in these circumstances, the party here in this case, the plaintiff is in breach of the contract, and now he cannot point out the defendant saying that there is breach from the defendant side, as a well-known proverb goes that a buffalo cannot say to the cow that this I am passing over. In view of the facts and discussion made at issue number 8, the plaintiff has not proved this issue against the defendant. On the contrary, it is a fact on record that the defendant could not start the work and complete the same in time due to defaults, omissions and deficiencies on the part of the plaintiff. And as a matter of fact, under the law, the moment the plaintiff committed breach of the contract, the defendant could refuse to perform duty immediately and ask for damages, and defendant might continue the work to its completion and thereafter to ask for damage. Learned advocate for the defendant urged before me that the defendant firm is a reputed contractor and they selected to continue to work in its completion and thereafter ask for damages. But in the meantime, the plaintiff wrongly terminated the contract. Option is there, sir. And the Supreme Court has held also that where these two clauses are there, then contract does not become voidable at my option. Now, I know that there is an extension of time clause. I apply for that. And therefore, I cannot determine the contract as okay, now terminate. On the above proposition of law, the defendant has relied upon learned author Edmund and Gill's building and so rights of the contractor. I may pass over. These are the authenticated books on the building and engineering contracts, then in the circumstances, I do not find any fault or breach of the contract on the part of the defendant and decide issue number 4 in the negative. Issue number 5, same sir. I do not repeat here again and decide the issue number 5 in the affirmative. It was burden. Then issue number 6 is complete within 24 months, which is about the entire issue is the government rejected the third. Now I'll point out what happened. I have stated when first proposal for applying clause 2 was considered by the lowest hierarchy in hierarchy, he gave a proposal to the executive that 10 rupees to be 10 rupees is the nominal. Immediately that was increased to 232, to which the AC approved. Now it may sound very meager amount, but at that time it was 232 is a penalty. I am there for earning my bread and butter, and therefore I have to pay to my laborers. 232 was a, therefore I went to the department. I said, please, and that shows my intention, sir, that I wanted to work. I requested the department, this is too much. Department again recommended to higher authority by taking my word, promise, that I will continue, which I have given. So department approach to the AC approach to the government. Now government, that may be internally required. Contractually, it is the executive engineer and AC who has to decide. To that, what happened, whether government accepted the proposal or not, that is in the bottom of this. Kindly see the last 3 lines. But unfortunately, Your Honor has got that last 3 lines. 2370 exhibit 53 પછી છે. એમાં છે last third line. But unfortunately, the government rejected the third proposal, void its letter dated 14/12. Now this is there. But unfortunately, the government rejected the third proposal, void its letter dated 14/12. Now, if the government is to reject, is the rejection by the executive engineer because he is my engineer in charge? Contractually, government, what I mean the government is not the Gandhinagar government sitting at Gandhinagar. Contractually, my boss is executive engineer. Internally, yes, I do consider they have to take the approval from the government. So government, sir, did not, Gandhinagar, we know the position. It is very difficult to get through. In the Ukai Dam case, there was one incident, right? They wanted some divers to dive in the dam to find out something or to protect somebody. But the appointment was made of drivers. And the drivers went there. So this is what is the now the third proposal white letter. So it is also submitted from the plaintiff side that in the month of June 17, the defendant left the work from the, now kindly see, if this allegation is right, then my extension, right of extension, you don't decide my right about the extension of time, you don't decide about the recommended reduction of the penalty, you don't communicate with me, I therefore have to sit there, not to work. The defendant left the work from the site and therefore the executioner gave a final notice on Adar Basite to start the work and complete the same, and subsequently the executor took the decision and terminated under clause 3. જે આપણે પહેલા challenge કરી ચૂક્યા છીએ, and the court has found that there is no application properly done of clause 33. So this is exhibit 56, sir. Then I read last line. The learned advocate Shri Sukhani, in reply to the arguments of Shri Vaja, forcefully submitted before me that according to clause 2, item wise program was required to be prepared by the executive engineer, which is not done in the present case. And as such, there is no attraction of the clause 2 of the agreement, exhibit 38, and in support of his argument. So these are the repetition of same thing. I mean, no penalty can be imposed under clause 2 of the so and so. And then the finding in the same paragraph, I have gone through all these judgments, and all the above judgments say that the penalty is in terrorum, and the penalty simpliciter cannot be recovered until and unless the damages are proved. And considering the ratio of all these authorities, it is crystal clear that in the present case, the plaintiff has failed to prove such damages, and as such, no penalty can be recovered from the defendant. I therefore issue number 3 in affirmative. Then issue number 7 is about one claim of metal, which I finally say that it was wrongly rejected by the executive, hence I decide issue number 7 in affirmative. Then issue number 9, he has stated in his deposit that the work to be extended of rupees 219, it must be so and so was remaining, and looking to the exhibit so and so 937 written by the superintendent engineer, Rajkot, to the executive engineer, approval to the tune of rupees so and so for the tender, it is in affirmative. I don't deny કે આટલું કામ બાકી રહ્યું છે. Now number 10. Number 10 is while deciding issue number 846, I have elaborately discussed the pros and cons of this case, and I have held in issue number 8 that the contract was illegally terminated by the plaintiff, and when the contract is found to be terminated illegally, it cannot be said the work is legally completed by the defendant, and hence, and there is no evidence further from the recipient who carried out the work at the risk and cost of the defendant. I therefore decide issue number 10. Sir, there is no evidence. They have not brought the person whom they paid, what was the tender, how much amount, when they were, because the mitigation of loss principle also applies. Sir, if they want to recover the damages, they have to apply the legal duty to apply the principle of mitigation law. But in this case, I am not elaborately going to that extent. Issue number 11, I have decided issue 846 in favor of the defendant, and it is held that the plaintiff has wrongly terminated the contract. In this result, plaintiff is not entitled to claim damages of so and so. This is a risk and cost. Court has rejected what term is not. Then, sir, issue number 12, 13, they are all relating to the penalty, and issue number 14 may be seen. It is decided by me that the plaintiff has wrongly terminated the contract so and so, and elaborate discussion has been made while deciding and when it is held by this court that there is an illegal termination of contract, it is obvious that the defendant is entitled for the refund of so and so. This is about my claims, which makes a total of 1,12,000. And then paragraph 21 is not important. Then issue number 15. This is regarding hand broken metal. Issue item number 9 of the tender. My witness has said that the department had rejected, and therefore I am entitled. Then issue number 16 is about beam, which I had to do extra work, for which the court has given me some amount. And then, sir, last issue is about loss of profit. Now, loss of profit, there are 4 judgments. Kindly see, one is 77 Supreme Court 1481. Honorable Court has decided, એમાં 15% આપેલા. 15%. I say that 15% is not enough. I mean, it is not the upper limit anywhere. It is not the lower limit anywhere. But 10 to 15% is the limit, which I pointed out in the ground that they say that 75,000 has been awarded. Kindly see the last. I hold he is entitled only for an amount of rupees 37,500, being 15% towards the remaining work, that is 2,50,000, and hence decide this issue accordingly. So this is the amount which has been granted. Now disallowed claims are paragraph 25. I have said that court has not granted me entire amount, and therefore the claims which have been disallowed, I have not come in the appeal, sir. So there is no question of reading that. No appeal is required by me. And the order is that 121 is awarded with 12% interest. At that time, it was reasonable, and there is no challenge to it that 12% is high. So these are my submissions. In short, the learned trial judge has not committed any error. The issues are widely framed, covering all aspects of the matter. The reasoning and conclusions derived are based upon the well-known ratio laid down by the Honorable Court and Honorable Supreme Court. Therefore, this appeal does not deserve to be considered.
ડાયવર્ઝન બાબતે સર અમે પેલું કઢાવ્યું છે સર બંને બાજુ ખરાબાની જમીન હતી અને એક બાજુ અમારો
ખરાબો છે તે બી જૂના સમયથી જ છે એટલે જે ખરાબો બન્યા સાઈડ છે એ જો
અમારો એક એક્ઝિબિટ 85 છે એ 15 પાનાનો છે. It covers 85 pages. Your Honor, if see that is at the end, it covers almost every aspect of it. It એનો જવાબ જ આમાં પેપર લાવ લાવ 2,970
જમીન સંબંધ કરી વાત કરીને ડાયવર્ઝન આપેલું
આટલી બધી ડિટેલ લખીને મારે કામ કરી સાહેબ નાના કોન્ટ્રાક્ટર હોય અનઓર્ગેનાઇઝ આઈ વોઝ નોટ ઇન્ટરેસ્ટેડ ટુ રન અવે મારે ત્યાં જ કામ કરવાનું ત્યાંનો રહેવાસી
ભાઈ 145 છે ને સાહેબ આ
19 પાના છે એક્ઝિબિટ 85 આપું છું
145 થી શાંતિલાલ શામજીભાઈ પારેખની જે
ઇન્ચાર્જ કાર્ય જે તે વખતેના કાર્યપાલક
જમા લેવાની એમાં ક્રોસમાં સાહેબ આ હકીકત એટલે છે રેકોર્ડ ઉપર ડાયવર્ઝન એ વાત કરી હતી કે અમોએ ડાયવર્ઝન આપેલ ન હતું ને ડાયવર્ઝન અંગેની વાત છે સાહેબ એમાં એ વાત કરી હતી કે વર્ક ઓર્ડરની સાથે જ કોન્ટ્રાક્ટ
ને કામ
ને કામની ડિઝાઇન
વર્કિંગ ડ્રોઈંગ્સ
અને સર્ટિફિકેટ કોપીઓ રાખવાના હોય છે એ વાત કરી છે કે પ્રતિવાદીને આઇટમ વાર પ્રોગ્રામ આપવામાં આવેલ ન હતો કારણ કે જરૂરી ન હતું એ વાત કરી હતી કે ટેન્ડર બહાર પાડતા પહેલા જમીન એકવાર થઈ જવી જોઈએ એટલે એનું ડિનાઇલ નું સ્વરૂપ છે સાહેબ એમાં એને કીધું કે ડાયવર્ઝન હતું પણ રેકોર્ડ ઉપર એના કોઈ દસ્તાવેજ ક્યાં હોય હતું એવું છે
સર જે શેડ્યુલ બી છે એમાં શેડ્યુલ બી સર અમારું જે શેડ્યુલ બી છે એમાં આઈટમ નંબર 8 અને આઈટમ નંબર 8A એ સર ડાયવર્ઝનની આઈટમ લીધેલી છે સર એમાં. હા સર આઈટમ લીધેલી જ છે. હા સર.
વાંચો વાંચો.
Item number 8, diversion of water policies providing for dam and burn or ice dam is maybe necessary for pier and abutment foundation dewatering during the excavation and until completion of the foundation stub its completion for Ojat bridge.
ડાયવર્ઝન ઓફ રોડ એક્ઝિસ્ટિંગ જો આ બ્રિજ જે છે ને ચાલુ રોડ ઉપર બનાવવાની હતી.
જી સર.
તો એ ટ્રાફિક જે હતું ને એ ટ્રાફિક આમ ના જાય એ બાજુમાંથી જાય એનું એ નથી આ.
ડાયવર્જન છે ને એમાં કોફર ડેમ એક ટાઈપ જ છે ડાયવર્જન નો અંદર કે માટીથી પુરાણ કરીને
મને ખબર છે બેન આ 50 ડાયવર્ઝન અમે જોયા અમદાવાદથી અહીંયા આવતા એને માટી પૂર્ણ કરીને સાઈડમાંથી જાય એવો ડાયવર્ઝન જે છે આ ચાલુ બ્રિજ હતું.
ડાયવર્જન નું પ્રોવિઝન આપેલું છે. ડાયવર્જન ની અંદર પાણીને વહેણ માટે કોફર ડેમ કરવાનું છે એટલે ડાયવર્જન નો તો શબ્દ લખ હા
સર
એટલે ટ્રાફિક ને બંને એના ઉપરથી જ જઈ શકે.
સર એમાં ઓનલી આઈટમ આપી છે એક્ઝેક્ટ મતલબ ડાયવર્ઝન નો મિનિંગ તો એ જ થાય કે તમારે વેહિકલ ડાયવર્ઝન કરવાનું હોય છે સર. જે ટ્રાફિક નું ડાયવર્ઝન હોય એ જ ડાયવર્ઝન નો મિનિંગ થાય છે. હા સર એ બી છે પણ આમાં વોટર કોર્सेस પ્રોવાઇડિંગ કોમ્ફર્ટેબલ એન્ડ આઇસલેન્ડ સર એના ઉપરથી જ જનરલી અત્યારે જે બધા અમે બ્રિજીસ બનાવીએ છીએ. Diversion of water courses providing coffer dam in Iceland is may be necessary for piers and abutment. એટલે એબટમેન્ટ અને જે પિયર માટે ડાયવર્ઝન બનાવવા માટે જે ડાયવર્ઝન જરૂરી છે કેમ કે સર જે અલાઇનમેન્ટમાં અમારે બ્રિજ બનાવવાનો છે ત્યાં તો ટ્રાફિક કે કોઈ બીજું કે પેલું ચાલી નહીં શકે ત્યાં પાણી બી ના રહેવું જોઈએ એટલે સાઈડમાં એ ડાયવર્ઝન બનાવે છે એમાં એના લીધે જે અમારું પિયર અને એબટમેન્ટ હોય છે ત્યાં પાણી બી ન આવે અને પેરેલલી ટ્રાફિક બી ત્યાંથી પસાર થઈ શકે સર.
તો પાણી અને ટ્રાફિક એક જ રસ્તે તો ના જાય ને.
હા પણ સર મારું
પાણીને ડાયવર્ટ કરવા માટે
પાણીને ડાયવર્ટ કરવા માટે જે છે ટ્રાફિકને ડાયવર્ટ કરવા માટે ક્યાં છે?
સર એમાં મેન્શન નથી કર્યું.
અબેટમેન્ટ તમે બનાવો અબેટમેન્ટ તમે નદીના ગોર્જ પોર્શનમાં હોય ને.
જી જી
સાહેબ અત્યારે જે કઈ કે પણ એટ ધેટ ટાઈમ વોટ ઇઝ ધ એવિડન્સ ફોર ધેટ ઇઝ ઇમ્પોર્ટન્ટ.
શેડ્યુલમાં આઈટમ છે
આ આઈટમ નહીં તો એનો જવાબ આવે. let me say that this is there. Is there any single letter that this diversion which I am asking is an item under the tender? What are you asking for? Do it. મને આટલું તો કહે ને સાહેબ. હા હા હા. But this is not, kindly see, this is not the diversion of the traffic. That is, so I am on. No, this is not for the.
સર
અને આવો જે છે ને સ્ટેન્ડ they have not taken there.
અરાઉન્ડ 70% જેટલું બ્રિજનું કામ પૂરું થવા આવ્યું હતું તો સર ત્યાં સુધી અરાઉન્ડ 2 વર્ષ સુધી ટ્રાફિક ન ચાલ્યો હોય એવું તો પોસિબલ છે ને.
ચાલતું હોય
શરૂઆતમાં જે નથી આપી લે છે પછી તમે આટલું
એવું સાહેબ એવું છે સાહેબ કે 14/11/17 ના રોજ જે વર્ક ઓર્ડર થયો સાહેબ કામ એનું ચાલુ થયું માર્ચ 1968 માં.
ઓલરેડી સર 4 મહિના પછી
એ તો રેકર્ડ ઉપર છે સાહેબ. એટલે જે આટલા ટકા જે કામ થયું એની પહેલા શું અમને પરિસ્થિતિ પણ એને સાહેબ કામ જ સાહેબ મોડું કર્યું. 11 એટલે સાહેબ લગભગ 4 મહિના સાહેબ મોડું કામ ચાલુ થયું. એટલે 4 મહિના સુધી કઈ
એનું કોઈ પ્રતિક્રિયા નથી.
હા અને એ અંગેનો કોઈ એવી જે તે વખતે રજૂઆત નથી સાહેબ કે આ અમને અડચણ છે.
મારી જુબાનીમાં છે સાહેબ.
પણ એટલે
એનું ક્રોસ
લેખિત આધાર તો જોઈએ ને સાહેબ.
આ જુબાન
આજે આવી ડિપોઝિશન માં જે કઈ આવે સાહેબ એનો
એ લેખિત
એની વેલ્યુ ક્યારે નક્કી કરે?
લેખિત ઓર્ડર એક્ઝિબિટ 85 અને મારી જુબાની આપજો સર.
મોડું કામ ચાલુ કર્યું છે 19 માર્ચ 68 માં સર. અને 11 69 માં તો સાહેબ કામ પૂર્ણ કરવાનું છે.
Sir, paragraph 2 of exhibit 160. પેરાગ્રાફ 2. 26/11/66 દિવસે હું દાવાવાળા કામ ઉપર સાઈડ ઉપર આવેલો. આ દાવાવાળું કામ આશરે 7 લાખ રૂપિયાનું હતું અને દાવાવાળા કામમાં 2 પુલો બાંધવાના હતા, એક નાનું અને મોટું. તે બિરખા વૈસાવદર પુલમાં 6 પાયા અને 2 અબેટમેન્ટ બાંધવાના હતા અને નાના પુલમાં 2 થી 2 પિયર અને 2 અબેટમેન્ટ બાંધવાના હતા. આ કામ પિલરનું ઓપન ફાઉન્ડેશન હતું અને બિલના વિસાવદરના રસ્તા તથા ચાલુ જ રસ્તા ત્યારે ચાલુ જ હતું અને તેથી રસ્તો ચાલુ રાખવા માટે ડાયવર્ઝન કાઢવું પડે, જેથી ડાયવર્ઝન બાંધવાનું હતું તે કરાર પ્રમાણે બાંધવાનું હતું. મેં ત્યાં ઓફિસ, ગોડાઉન અને 24 છાપડાઓ આ 2 પુલોની વચ્ચે બાંધેલા હતા. આ જગ્યા ત્યાંના સુપરવાઇઝર શ્રી વોરા સાહેબે બતાવેલી અને આ બધું બાંધવામાં મેં રૂપિયા 4,000નો ખર્ચ કરેલો. પછી જમીન માલિકે વાંધો લીધો અને કહ્યું કે તમે અહીંથી નીકળી જાઓ, જેથી અમે બધા જ છાપરાઓ કાઢી નાખી જુનાગઢ સાઈડ તરફ ગયા. આ જગ્યા પણ વોરા સાહેબે બતાવેલ. આ કામનો વર્ક ઓર્ડર સોનસો. So this is the initial hindrance which I have faced.
એનો આધાર શું સાહેબ રજૂ થયો?
આધારમાં આનું
એવું સાહેબ આ વાત
આનું ક્રોસ
આવી.
શું છે એ જુઓ સાહેબ. અને મારા આધાર છે સાહેબ આ કે 80 પ્લસ અધર લેટર્સ. 85 જો ના.
આને લગત જે સાહેબ જે મારા મિત્ર સાહેબ કીધું કે જમીન માલુકે વાંધો એટલે લીધો, એવી રજૂઆત એમની સાહેબ કઈ કચેરીમાં સાહેબ વાદી કચેરીમાં થઈ છે?
માટે નથી, આ તો તેના લેબર માટે છે.
હા પણ એ ખબર ને. એને સાહેબ જે અડચણ થયું તો એને લેખિત રજૂઆત સાહેબ
હા, એ વાત ખરી નથી કે હા નહોતું ને તૈયાર છે. હા એટલે I'll read it. Let me read it. હા હું સમજો 2 નેગેટિવ આવે છે. Let me see it. હા એ વાત ખરી નથી કે આ કામમાં કોન્ટ્રાક્ટ મુજબ એન્જિનિયરિંગ ઇન્ચાર્જ ન હતો. એ વાત ખરી નથી કે આ કામમાં એન્જિનિયરિંગ ઇન્ચાર્જ. હા મારી ક્રોસ વાંચું છું ને સાહેબ.
પાના નંબર 6.
એક પેરાગ્રાફ 9 કહો છો ને સાહેબ? એક મિનિટ કાઢો ને, ક્યાં છે? યસ સર. હું ગુજરાતી ભણેલો છું. 1957માં મનુભાઈ કંપનીમાં દાખલ થયો. એ વાત ખરી છે કે વર્ક ઓર્ડર મને રૂબરૂ આપેલ નથી અને સદરો કોન્ટ્રાક્ટના કામ ઉપર પ્રતિવાદીએ સને 1970ની સાલ સુધી રાખેલો મહિનો કે તારીખ યાદ નથી. હું પ્રતિવાદી પેઢીના પત્રોનો કરેલ સહીઓનું ઓળખી શકું. એ વાત ખરી નથી કે વર્ક ઓર્ડર આપ્યો ત્યારે રસ્તાનું ડાયવર્ઝન તૈયાર થયું ન હતું. એટલે હતું. હા, એ વાત ખરી નથી કે અમે જે છાપરા ઉપર બધું આખું વાંચવું પડશે. બટ ધ ફેક્ટ ઇઝ આઈ હેવ રિટન ધ લેટર્સ this may be, I am not given a proper understanding. In my pleadings also it is there that the diversion is not there. And their witness says,
સર ક્લોઝ 2 માં એવું છે કે 1/4 એટલે મતલબ 25% કામ ગાળામાં સર હા દિવસમાં કમ્પ્લીટ થઈ જવી જોઈએ. 1/4 એટલે 25% કામગીરી 1/3 ટાઈમમાં થઈ જવી જોઈએ.
જજમેન્ટમાં બી લખેલું છે પણ હું સેપરેટ કોપી લાવ્યો છું. અચ્છા ને બિલકુલ.
આ છે અમારું જે એગ્રીમેન્ટનું પેલું છે એ છે આઇટમ રેટ ટેન્ડરમાં પેજ નંબર ટેન્ડર ઓફ વર્કમાં જે આ ક્લોઝ છે. હા જે ટાઈમ લિમિટ સાથે આપેલું છે પ્રોગ્રેસ પાછળ કદાચ હશે. ઓકે
તો તમારા 100 વર્ષથી આ જોબ છે. એ જ છે સાહેબ. હા, આ પણ તમારા માટે.
મેન્શન કરેલું.
આ બીજા જ કામનું છે. હું હાઈકોર્ટમાં જાઉં છું.
148 અને આઈટમ 148 છે એમાં. ઓલું ભાઈ આ 148.
પેપર બુકમાં નહીં હોય.
હા ઓરિજિનલ
સર ફોર્મ B2
માં જો 38 છે.
ફોર્મ B2 છે સર એમાં
ઉભા રહ્યો 38 માં છે. પણ સાહેબ
હા, એ જ
આ
છે.
જે રજૂ કર્યો એ નથી.
અરે એ જ
ઓલું,
છે.
આ પણ એક મિનિટ ઓલું જોવે એટલે સાહેબ ખ્યાલ આવે. 38 કે 148 બે થી રજૂ થયું છે.
તમારા ઓફિસર હા પાડે.
આ પણ ઈ આ પડે એમાં ક્યાં ટાઈમ લિમિટ છે એમાં
નહીં એમાં મેન્શન નથી.
પછી
આ જે ટાઈમ પર્સન્ટેજ જે તે વખતે આ બધું પેપરથી પેનથી લખેલું છે 1/4%.
એમાં છાપેલું
સમય નથી.
નહીં છાપેલું નથી
છાપેલું છે.
લાવ
લખેલું છે.
ક્લોઝ 2 તમે બીજું વાંચવાનું બંધ કરો. ક્લોઝ 2
છે એમાં મેં તે દિવસે જોયું. સમય નથી.
હા એ 1/4
હા.
1/4 60%
નહીં.
mention કરેલું.
અને આ છે કે નહીં નોટ.
સર જે ક્લોઝ 2 છે એમાં ટાઈમ મુજબ વર્કનો પ્રોગ્રેસ થવો જોઈએ એ મેન્શન કરેલું છે. એમાં સર મેન્શન કરેલું એવું છે કે 25% જે કામ છે એ 1/3 ટાઈમ લિમિટ મતલબ આપણા 24 મહિના છે તો એના 8 મહિનામાં 25% કામગીરી પૂરી થઈ જવી જોઈએ. 50% કામગીરી 1/2 એટલે મતલબ 12 મહિનામાં કામગીરી પૂરી થઈ જવી જોઈએ. અને 75% જે કામગીરી છે એ 3/4 મતલબ અરાઉન્ડ 18 મહિનામાં કામગીરી પૂરી થઈ જવી જોઈએ. જે કન્સર્ન કોન્ટ્રાક્ટરે કામગીરી પૂરી એ સમયમાં નથી કરેલી.
સેમ છે સાહેબ એ મારું એમ આ છે.
આપણે અસલ જોશું ને
હા,
આપણે.
અસલ જોશો ને
હા રેકોર્ડ ઉપર જ્યાં આ પડ્યા ઈ
બસ ત્યાં ખાલી પેજ આ તો વાંચવા ના આવે એટલા માટે અને નીચે નોટ છે સાહેબ એમાં હા 38 બી એ જ
લાવો
છે
ને એક મિનિટ લાવો.
ફોર્મ B2 એમાં ત્રીજા નંબરના પેજ ઉપર છે.
પાના નંબર 3.
આઇટમ રેટ ટેન્ડર એન્ડ કોન્ટ્રાક્ટ ઓફ વર્કમાં ત્રીજા પેજ ઉપર.
પેલા પાના ઉપર છે ને એવું લખ્યું છે. આ સાહેબ જે વાંચે ને ભાઈ ખડુભાઈ
જે ફોર્મ નંબર B2 છે એમાં એવું લખ્યું છે આઇટમ રેટ ટેન્ડર.
પીટું છે ને એમાં એવું લખ્યું ઓલા બે લીટા વચ્ચે હા યસ યસ હવેનો પાના નંબર 3 હા બસ ન્યા હા જો એમાં ન્યા એમાં
ક્લોઝ
છે ને
નંબર 2 હશે.
ત્રીજો પેરેગ્રાફ 2 અને પછી એમાં 113 112
નહીં,
જોયું
one by three, one by three.
એમાં વચ્ચેના ભાગે છે હવે ઈ જે છે ને ક્લોઝ ટુ એટલે એનું સાહેબ ઓલું પૂરું થાય ને મંથ ટુ કમ્પ્લીટ એવો છેલ્લે પેરેગ્રાફમાં શબ્દ છે સાહેબ એની નીચે સાહેબ આ નોટ કરેલી એક મિનિટ સાહેબ શું સાહેબ? એટલે સાહેબ હું સાહેબ આપણા અમદાવાદ જે પેલો બીજો તે ક્લોઝ ટુ પછીની જે છે ને
હા.
હા હા એટલે એના પછી
The quantity of work to be done within a particular time to be specified above shall be
થોડું કપાઈ ગયું
component to accept the contract after taking into consideration of circumstances and instant in the blank space kept for the purpose and abide by the program
to be laid by the
executive engineer. Sir,
એનો વિટનેસ કે છે કે નથી બતા
આપણા witness શાંતિલાલ પારેખ.
ઉલટ તપાસ છે
સર એમાં અમારા જે કાર્યપાલક શાંતિલાલ પારેખની જુબાનીના પોઈન્ટ નંબર 2 માં પ્રતિવાદી ઓજત નદી ઉપર પુલ બાંધવાના કોન્ટ્રાક્ટમાં તે સમયે આપવામાં આવેલો પ્રતિવાદી કોન્ટ્રાક્ટ નિયમો મુજબ કામ કરતા ન હતા તેથી તેને અમોએ નોટિસ આપેલી હતી તેમજ અમે તેને એક ટેલિગ્રામ પણ કરેલો હતો તથા અંક 24 ની નોટિસ 44 ની નોટિસ પ્રતિને આપવામાં આવેલ હતી તે પ્રતિને વારંવાર પત્રો લખેલ હતા છતાં પ્રતિ કામ ધીમું કરે છે.
145
સર શું નંબર હતું?
આ છે ₹120. મિસ્ટર ધીરજલાલ, એને ક્રોસ એક્ઝામિનેશન 108 કે 120 સાહેબ. આંક 38 ના શેડ્યુલ બી માં 42 આઈટમનું કામ કરવાનું હતું. સદરૂપ 42 આઈટમ પૈકી કોઈ આઈટમને કેટલા સમયમાં પૂરી કરવી તે અંગેનો આઈટમ વાઇઝ પ્રોગ્રામ ડિપાર્ટમેન્ટ નક્કી કરેલો નહીં.
પાના નંબર 5
અમારા વકીલ સાહેબ ના એ છે. હા, જુબાની શ્રીવાસ્તવ કરી છે. ફરી સોગંદ પર સત તપાસ. હા, ધીરજલાલની ઉલટ તપાસ વકીલ શ્રી સુખવાણી સાહેબ. હા 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 હા, ક્લાસ 13 પણ એમાં ક્લાસ 13 નું પણ ઉલ્લેખ કર્યો સાહેબ. આપ 30 છો બરાબર ને? હા, એમાં આઈટમ વાઇઝ નું એ છે ને સાહેબ. આંક 38 ના શેડ્યુલ બી માં કુલ 42 આઈટમનું કામ કરવાનું હતું. સદરૂપ 42 આઈટમો પૈકી કઈ આઈટમનું કેટલા સમયમાં પૂરી કરવાની તે અંગેનો આઈટમ વાઇઝ પ્રોગ્રામ અમારા ડિપાર્ટમેન્ટે નક્કી કરેલ નહીં. હા, અને એનો 5મો પેરાગ્રાફ જોશે. એ વાત સાચી છે કે પ્રતિવાદીઓ અમારા ખાતાને વારંવાર પત્ર લખતા હતા. જમીનના કબજો નથી, ડાયવર્ઝન કરેલ નથી, ડિઝાઇન અને ડ્રોઈંગ્સ ચેન્જ કર્યા છે. અને પ્રતિવાદીઓએ એવા પણ પત્ર લખેલા છે કે અમારું ખાતું લોખંડના સિવાય આપતા નથી. તથા 7/8/68 રોજની મીટિંગમાં હું હાજર ન હતો. આંક 64ની નોટિસ પ્રતિવાદીએ અમારા ખાતાને આપી, એટલે જ અમારા ખાતાએ કરાર રદ કરીને એવું કર્યું. આફ્ટર આઈ સર્વ ધેમ નોટિસ.
એ હું કહી શકું નહીં.
હા, એટલે એ નોટિસ નો તો
એવું છે છેલ્લે.
એટલે એને યાદ ના હોય ને તારીખ, એટલે કહી ના શકતો. બાકી તારીખો તો છે. એટલે વોટ ઇઝ હા એમ. હા હા હા, પત્રો લખેલા છે. હા, એટલે નવો પત્રો લખેલા છે. જો સાક્ષીને ડિપાર્ટમેન્ટે લખેલા હોય સામે, તો એનો કે મારા પત્રનો જવાબ છે, આ વાત ખોટી કહેલી છે સાહેબ. અત્યારે આપણે જે whatever is the evidence at that time, that is to be seen.
ડાયવર્ઝન બાબતની વાત સાહેબ આપણે હમણાં કીધું એની ઉલટ તપાસમાં સાહેબ એને કબૂલ કર્યું કે ઈ હતું. એ ઉપરાંત સાહેબ જે વર્ક કરવાની વાત છે ઈ સેવામાં ડિપોઝિશનમાં જે આવ્યું છે પણ સાહેબ આપને જે સાહેબ બતાવ્યું ક્લોઝ B વાળું 2 વાળું એમાં સાહેબ સ્પષ્ટ છે કે એટલા સમયમાં એને કામગીરી પૂર્ણ કરવાની એ સાહેબ થઈ જાય. Right? હા ઠીક છે આનું હા. બરોબર પણ સાહેબ જે દસ્તાવેજ રજૂ થયેલો છે એ સાહેબ ધ્યાને તો લેવો પડશે.
Obliged, sir. And I'm leaving, I'm little hurry because it is very difficult to reach there.
એક આપનું ધ્યાન દોરજો સર કે જ્યારે વડી અદાલતમાં અપીલ સાહેબ દાખલ થઈ પ્રથમ વખત ત્યાં સાહેબ એમના આદેશ મુજબ છે રકમ ડિપોઝિટ કરાવી હું તો છે સર બેઠું હા
હા એ તો છે જ ને. તો we are
છે એમ કરાવેલી ત્યાં.
બીજી વખત હું લઈશ નહીં તમારી પાસે.
એવું વાત નથી આ તો નામદાર કોર્ટના ધ્યાને રહે કે ત્યાં ડિપોઝિટ કરાવે.
સાહેબ એમાં એક
બીજી વાર લેવાની વાત નથી.
ત્રણ પાર્ટીઓ કરી છે હજુ એ તો they have joined 3 persons. One different જો તમે plaintiff number 1 is my ત્રીજો નંબર પાર્ટનર જ નથી એ કઈને થાક્યો પણ ડિલીટ નથી કરતા. એક્સ પાર્ટી ખાઈ that now is obliged, sir, and thank you for so.
એ સાહેબ આવતા શુક્રવાર સાહેબ બતાવી દઈએ.
નહીં મને તો મેં આમ અને સાહેબ જો કોઝ ઓફ એક્શન છે બી તો બી મને વાંધો નથી. Obliged.